The thing about the collaborative process that I think is extremely important here in construction, in medical error, in all areas, is that the parties must assume responsibility for their own acts. And that is the key to determining whether or not a person can participate in the collaborative process. If someone is not willing to accept responsibility, then they're not going to come out of the process with an agreement. I have clients sometimes that will say, that's not my fault. And recently I facilitated a sexual harassment retaliation case. I did not represent the parties. I acted as a facilitator. And the company and the lady who was alleging the harassment, and actually it wasn't even alleged, the company admitted that it had happened, but they each had their own lawyers. And the company lawyer kept telling me, you know, it's not our fault. This man was told he shouldn't behave this way, and they went on and on and on. And so finally, in a private session, I said, excuse me, how did this man get in the company? Well, what do you mean? Well, how did he get on the premises? Well, he was an employee. Well, who hired him? Well, we hired him. So I guess you're responsible for him being there. Well, yeah. Well, if you're responsible for him being there and you're responsible for the lady being there, then I guess maybe you have to take some responsibility about the fact that they had this contact, don't you? And, you know, they thought for a minute and began to think, well, yeah, they really did. So in most every case you find there's going to be responsibility on the part of the parties. Because unless you're a victim to a drive-by shooting, you've got some responsibility. And even then, if you knew you were in a bad neighborhood and you shouldn't be walking down that street, well, perhaps you'd have to still accept a little responsibility. So that's one of the things that I think we have to talk to people about, is the acceptance of responsibility. The same thing in the construction deal. The prime contractor said, this was the subcontractor's fault. It wasn't my fault. Did this guy just show up off the street and come out on the job site? Well, no, I hired him. Then I guess maybe you've got some responsibility, don't you? So this is a hard thing for us to do as lawyers, because we're used to telling our clients that they're not responsible, that the other side is fully responsible, and that they're to blame for everything that happened. And the more we can blame the other side, the more money or the more results we can expect to get for our client. But in the collaborative process, we don't talk about blame. We talk about who is responsible. This is so important, because if I sit and I say, you are to blame, you did this and you did that, that person is not very likely to want to work with me to come to some good result. But when I can talk about how I feel about what you did and how what you did affected my life, or I can teach my client to speak that way, then the other person is going to listen, and they're going to come back and say, well, I didn't mean it that way, or they're going to explain what they did and why they did it, and there'll be an exchange there. And that exchange can lead to ideas on how we can settle the dispute. So this is where these people have to be taken in order to be able to accomplish too much. And then, of course, there's elder law, which is extremely important and very difficult. You've been a caretaker of your children, and now all at once you're a caretaker for your parent. And your parent doesn't want to be taken care of because they think they can still take care of themselves, and actually some of them can. And the children trying to be caretakers need to understand that. So there's a give and take there, a changing of roles, that the collaborative process can create a forum for healing, for understanding, for hearing each other, that perhaps would not happen if the people were left on their own. I see the process as a way of not just settling disputes, but avoiding disputes. So when something has to happen, for instance, a parent is trying to decide how to set up a will, how to pass a business on, a farm, some large piece of property. How do I pass this on to my children? Well, I could just set it up the way that I want to, and after I die, let them duke it out. Or I could let them go ahead and get upset with me right now, but preserve their relationship later. So I call them all together and I get their thoughts on what needs to be done. I share my thoughts with them. We talk together, and perhaps I can work out something so that when I die, there won't be a lot of hard feelings, controversy, or why in the world did Mother do that? So you see, this can be used not just for disputes that we have, but to prevent disputes. It can be used to negotiate contracts in transactional areas. It's already being used for prenuptial agreements. And I don't know why it couldn't be used for any type of contract, and build into the contract that if there's going to be a dispute in the future, if one arises, that the people will try the collaborative process before they use any other form of dispute resolution. So basically, you're setting up a model now for people to use in the future if they have a problem. And once somebody successfully completed resolution of any dispute in the process, I think they're going to find it far superior to other methods of trying to get things done. I think that ongoing relationships are extremely important, and that the process can make a big difference with that. But I don't believe it's a mandatory prerequisite to using the collaborative process. You may have an ongoing relationship that you want to preserve, but there could be something that happens between two people, some sort of accident that happens. And certainly the collaborative process would not be precluded from that, because there can be a lot of upset and anger from an automobile accident, for instance. You know, you ruined my car, you hurt my child. Being able to sit down with the people and have a discussion about how to resolve things would certainly be better than litigation. And there may be no ongoing relationship there to preserve. Nevertheless, it can be much less stressful on those that are participating in the process, and a lot of understanding can be gained by it. And when someone is hurt or damaged in some way, the ability for them to tell the other parties how that's affected their lives, I think, is very important to them, which they're not going to get that chance in litigation. And I think it's also important for the offender to have the opportunity to apologize if that's what they feel like they want to do. Apology is something else that cannot be court ordered. A court can't order a change in hospital procedures. They cannot order a change in product design that has hurt someone. They can't order me to tell anybody I'm sorry. But this can happen in the collaborative process. In the sexual harassment case, I don't think that would have ever settled, except when the employer heard the effect that that had had on the life of this woman. There was a very, very sincere apology given. And after that apology, the atmosphere in the room changed entirely. And we began to talk about getting things resolved. And the tension somewhat subsided.